Yep. Well, Neal, tell us what you've been up to since we were together last time.
Well, I'd like to start out by telling you a little bit about myself for those of you who don't know me. My name is Neal Coffman. I am currently the child support hearing officer for mostly Volusia County. Been a member of the bar for about 15 years. In that time, I've done a few years of private practice, a few years working for the Department of Children and Families, prosecuting child abuse, neglect cases. And in addition to that government work, I've been the child support hearing officer sitting on a bench 3 days a week for about the last 7 years. In that time, I feel that I've learned to make good decisions, and one of the most sometimes difficult but rewarding things is applying the law as written and not how we wish it was. We all think that if we were elected to the legislature, we could probably do a better job, but that's not the judge's function. The judge's function is to apply the law as written by the legislature and signed by the governor. Let me just be honest with everybody. I think that becoming a judge would be somewhat of a natural progression for my career, but I by no means think that I'm entitled to it, nor I don't think anyone else is either. I would be deeply honored if I were provided the opportunity. I'm also somewhat excited by the fact that I've become aware from the Chief Judge that this vacancy will likely be used to fill the Unified Family Court Dependency Division here in Flagler County. I would be very excited about assuming that role, or any other role to which the Chief would assign me, of course. But I feel that I could pretty much walk into that role, given my experience in family law as well as in dependency law. And I am open for any questions that the Commission has.
I know you've submitted a number of applications with us.
I have.
Do you know how much do you go back and redo the application? How much do you circle back with every reference and remind them of your qualifications and refresh those as you work with new judges or new lawyers? Not new lawyers, but different lawyers.
I do try and do that. Every time one comes in for one of these interviews, of course, the question is racking the brain. What could I have said differently, or what could I say? But honestly, I am who I am. I feel that I am highly qualified for this position, and I would be deeply honored by the opportunity to serve. I consider it not only an opportunity, but also a sacred honor and really a duty to serve the people and apply the law as written. I've always believed in that. I believe in our judicial system, and I think that without it, society would descend into chaos. I know it may sound cliche, but I truly believe in the work that the court system does. And yes, I do try and keep in touch with my references as much as possible, and as far as I am aware, they are all still very supportive, and they're wishing me well.
What's your favorite part of the job that you do now?
Being on the bench and actually conducting the hearings. That's the part that I love. Office work, honestly, is office work. Whether you're a judge, a hearing officer, or you work in a cubicle at IBM. But there's something about being in court and listening to the arguments made by the attorneys and the parties, knowing the statutes well enough to be able to apply them, not just after you do some research a few days later, but I consider it to be very important to know the statutes well enough to correctly apply them from the bench. And I've worked very hard on making sure that I do that. And honestly, I'm very proud of the work that I've done as a hearing officer. I love what I do, but I feel that I'm capable of more, and I would really like the opportunity to serve as a judge.
Which judge are you aware of that you're most like in terms of how you run your docket in your courtroom?
I spent 2 years in front of Frank Marriott, and those were two of the most rewarding years in my professional career as an attorney, because I feel like I learned a lot from that particular judge. He was fair, but at the same time, he was quick and he kept things moving. I mean, nothing's worse, and I won't call anybody out, but nothing's worse than a judge that takes, 2 hours to hear a hearing that should only take 30 minutes. I think it's the responsibility of the judge to know the law well enough and know the case well enough before the judge goes in, to be able to rule, if not from the bench, certainly within a few days afterwards, and to not overly extend the hearing more than necessary. I think it's all about efficiency. And in the job I have now, it is all about efficiency. It's 40 a day, 20 in the morning, 20 in the afternoon, sometimes a few more than that. But, sometimes I do hour-long, 2-hour-long hearings as well, so I'm capable of doing those as well. But I think the new move in the judicial system will be doing more with less, and I'm excited about that. I really don't mind hearing a lot of cases quickly because I know that I know the law well enough to hear them correctly, accurately, while giving everyone a chance to be heard. And I think that's what's most important.
I know in your courtroom, you deal a lot with pro se litigants who are on one side. I know this, usually the state is on the other, Department of Revenue, they're represented.
Yes.
How do you deal differently as far as allowing them to speak, rules of evidence? How do you deal with those situations with the pro se litigants?
Pro se litigants, as most of you probably know, are another world. They know nothing about the process and how it's supposed to work. And it's a fine line that we walk every day. You have to be fair to every party, including the state and the lawyers who know what they're doing, as well as the pro se litigants who know nothing about what they're doing. And what I try and do is explain to them not what they should do to advance their case, but a little bit about the process while they're in court. When people come in with pro se contempts, I tell them that the standard for civil contempt and child support cases in Florida is willful failure to pay as ordered. It may sound like common knowledge to all of us, but a lot of them say, oh, okay. And then of course there's some who, it's like you said, nothing at all. But I don't say a lot more than that because I don't believe in judicial activism and I don't try and push an outcome in the cases that come in front of me. But I do try to educate a little bit at the beginning of a pro se session or hearing about just what the standard is, and then I take it from there. Sometimes, from the bench, as a hearing officer, you have to ask questions, but I try and shy away from that when possible, because that's not really my function. I'm the fact finder, not an advocate.
What else? Neal, thank you for coming in.
Well, I thank you all for the opportunity, and I would really appreciate the opportunity to serve, and I know I would do a good job. Thank you all.
Thank you, Neal. We'll be back with you this afternoon.